All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Good morning, everyone. Welcome. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Gucati&Haradinaj.
Thank you. Take appearances. Ms. Belici.
Good morning, Your Honor. For the SPO, we have today legal inter, Mr. Benjamin Dearden.
Thank you, Ms. Belici. Mr. Bowden.
Your Honour, will see that Mr. Rees appears by way of link. Otherwise, no changes to the team.
All right. Good morning, Mr. Rees. Mr. Cadman.
Good morning, Your Honours. We do not have Mr. Buckley with us this morning, and we're joined by Mr. Berisha.
Thank you. I also note that Mr. Gucati and Mr. Haradinaj are present in the courtroom. Before we continue with Mr. Reed, the panel wants to put on the record that after the Haradinaj defense uploaded the required documents in full, the following exhibits were admitted with Ms. Meyer's evidence. 2D7, which is the Public Interest Disclosure Act of 1998, 2D8, that is the EU Directive number 1937 of 2019, 2D9, which is the Protection of Whistleblowers recommendation of the Council of Europe, 2D10, which is the Kosovo Law 06/L-085, and 2D11, which is the UN Whistleblower Report. You all received an email this week with these new exhibit numbers. The panel also notes that these publicly available items, some of which are legislative documents, have been admitted because they relate to the testimony given by Ms. Myers as an expert witness and because there was no objection to their admission. As a matter of course, however, publicly available legislation or judicial decisions need not be admitted for the sole purpose of quoting the law or a particular legal interpretation. Where a judicial decision is relied upon for a factual finding, the panel can admit the document or take note of its relevant content. Before we continue with the examination, just a few points to make about the matters raised on Monday in court and yesterday via email by the Haradinaj defense. According to Rule 143, cross-examination has a broad scope. It generally pertains to the subject matter of the direct examination and matters affecting the credibility of the witness. However, where the witness is able to give evidence relevant to the case of the cross-examining party, he or she may be examined on that, provided that the cross-examining counsel puts the nature of the case to the witness. This is the case with expert witnesses as well. While the calling party is bound in its direct examination by the limits of the expert report submitted, the cross-examining party is not. Also, in accordance with Rule 143, Sub 1 and Paragraph 67 of the Order on the Conduct of the Proceedings, a cross-examining party can in principle use any document during its cross, whether they are admitted or not, and even if they have not been previously disclosed. Now, with this in mind, it is the responsibility of the calling party to weigh carefully the benefits and the risks associated with calling a particular witness to testify. In relation to the specific point raised regarding the use in cross-examination of reports authored by SPO staff who did not testify as witnesses, the panel reiterates that the truth and the reliability of these documents can only be tested through their authors. But these documents can be used to test the credibility of the current witness and the reliability of his expert report. So any line of questioning by the SPO should comply with this ruling. So let's have the witness now. Madam Court Officer, would you please put Mr. Reed on the screen? Good morning, Mr. Reed. We are ready to
morning.
proceed with the rest of your cross-examination. Are you ready now?
Yes, Your Honour, yes, I am. Thank you.
All right, and you can hear everything okay?
Yep, loud and clear. Thank you.
Thank you. All right, Ms. Bolici, you may continue.
Thank you, Your Honor. Good morning, Mr. Reed.
Good morning.
I would like to go back to your report, DNH 0857 to DNH 0868. And in
Yes.
particular, I would like to look at paragraph 14, which is on page DNH 0861. Now, you describe in this paragraph a search and seizure operation that you led in December 97 in the municipality of Prijedor in Bosnia-Herzegovina. Is this correct?
Correct.
And did you consult any documentation?
Yes, that's correct. You keep breaking up, but
Can you hear me, Mr. Reed?
yeah, I can hear you now. Yes.
There is a little bit of delay, I believe. Did you consult any documentation when describing this operation in your report, or you based this paragraph on your recollection?
No, I never referred to any documentation. This is my recollection, and it was according to our practices and procedures.
And how good is your recollection of events that occurred 24 years ago?
Well, it's not as good as what it was 24 years ago. But I still have a recollection of that particular mission, bearing in mind that was the first major mission we ever undertook. So yes, it's still sort of in my memory.
In the second period of paragraph 14, you state that a number of premises were searched.
Mm-hmm.
Do you recall how many premises were searched?
Yeah, I believe there were 3. There was definitely the police station, and there was definitely the municipal building, because I was the one that led the municipal building, and one of the other team leaders led the police station. Now, whether the third building was actually done, the SDS headquarters, I can't recollect now, but it was definitely on to be searched.
Okay. In the course of your testimony of last Monday, of the 24th of January, you mentioned the municipal building, the SDS headquarters, and the police station. The
Yes.
reference is at page 3213 and 3218. Wasn't a search and seizure also carried out at the radio station building in the same operation?
Again, I can't recall if it was the SDS headquarters or the radio station. You're correct. It could have been the radio station, because I do now recollect, now that you remind me of that, I recollect we brought back some reel-to-reel tapes, which were difficult to transcribe it or get the data off those reel-to-reels. So yes, now that you've reminded me of that, yes, that was the radio Prijedor, and it may not have been the SDS headquarters. You're correct.
So there were 4 locations searched, in fact. Is this correct?
Initially, yes, we probably had warrants for 4 locations. But now that you're sort of stimulating my mind a little bit, I think we only did the 3, and I was mistaken. I thought it was the SDS headquarters, but you're right, it was the radio Prijedor.
Was Mr. Mazar Inayat part of the investigative team that carried out the search and seizure operations?
Yes, yeah, he did I think Mazar he did the police station.
Okay. And I would like to refer you, Mr. Reed, to the transcript of the testimony that Mr. Inayat gave in the Brojanin case of the ICTY on the 28th of January 2002, and this is the document with ERN number IT 9936 T924 to T1007. And I would like to go to page 977 of the transcript. And I will wait for the document to appear on screen.
Sure. Yeah, I wasn't able to print those documents out, unfortunately.
Now,
Yes.
if you look at lines from 21 to 25th, you will see that
Yes?
to the question of the prosecution asking, now can you deal first of all please with the, sorry, I will start with line 16.
Sure.
Now can
Sure.
you deal first of all please with the seizure that took place first of all in the town of Prijedor? What did that happen? When did that happen, the first one? And the answer was the first Prijedor search and seizure took place on the 12th of December 97. And the question was, and at which location was the operation conducted? And the answer was the team searched 4 locations in Prijedor town. Those locations were the municipal building, the police station, the SDS offices, and finally the radio station building, which also housed the premises of Kozarski Viesnik. Now, would you accept that there were in fact 4 locations that were searched, so both the SDS building and the radio station building? Does this match with your recollection of events?
My recollection is that we definitely did the municipal building, that's correct. We definitely did the police station, that's correct. And now that you've reminded me, we definitely did Radio Prijedor, which also incorporated the newspaper, Kozarski Viesnik. Now, whether we did the SDS headquarters or not, I honestly can't remember today. I didn't think we did the SDS headquarters. Now that you've told me about the Radio Prijedor, I recall the reel-to-reel tapes. I'm not sure whether we were in a situation where we had the time or the military wanted us out of the place. But if Mazar said that in court in 2002, which is 5 years after, I'll accept that. That's not a problem at all.
So when you wrote in your report that 3 locations were searched, you did not check whether this information was accurate, did you?
I used it as an example of how we did our search and seizures and how we used effectively chain of custody and the seizure of documentation.
But when you wrote that 3 locations were searched, you wrote a number, but you didn't check whether the number was accurate, right?
No, I took it from my memory.
And your memory was not accurate because you accept that the testimony of Mr. Inayat was accurate instead.
I accept the testimony of Mr. Inayat, and I also accept what you have told me. And the minute you mentioned Radio Prijedor, yes, you stimulated my memory, and I remember the reel-to-reel tape. So yes, that's correct.
Thank you. You also write in paragraph 14 of your report that detailed inventories were not done at the premises where the search and seizure was conducted due to security reasons. Now, you didn't compile detailed inventories because in the circumstances of the case there were reasons suggesting that a detailed inventory could not be compiled. Is this correct?
At the premises where we did the searches, yes, that's correct.
Okay. And you did not consider that not compiling a detailed inventory at the premises would affect the integrity or authenticity of the evidence that you were seizing. Is this correct?
No, because we knew what we'd seized, and we did the inventories back at the military headquarters in Banja Luka.
You did not do a detailed inventory on the spot. Is this correct?
That's correct.
And if you would have considered that this would affect the integrity, authenticity of the evidence that you were seizing, you would have done it on the spot, wouldn't you?
Ideally, yes. We would have liked to have done it on the spot, but we took the advice of the military advisors who were getting concerned that we'd been at the premises for a long time. There were crowds starting to build up in the streets of Priador. And again, you know, you have to take the advice of the experts. And that's when we took the documentation. We had placed it into evidence bags. We had placed it into evidence boxes. We'd photographed it. We'd videoed it or videoed it. And we took it back to do the inventory back at the military headquarters.
Now, is it correct that at the beginning you intended to do this detailed inventory, but by midday you realized there was not enough time to proceed in this way, and then you decided to renounce to this step? Is this correct?
I don't know if it was midday or not. I don't recall what time we left. I thought we left sometime mid-afternoon. But if there's a document that says we left at midday, then we left at midday.
No, you realized by midday that there was no time to do this inventory that you wanted to do at the beginning, that the time was not sufficient to do what you wanted, and then you renounced to do this detailed inventory. Is this accurate?
We would have stayed there till 9 o'clock at night if we could have done the inventory. We took the advice of the military to remove us from the premises, to take us back to the military, to the base for security reasons. But no, I was more than happy to stay there till 9 o'clock at night and do the inventory.
I would like to just refresh your memory with the testimony of Mr. Inayat and the references to the same transcript, and the relevant pages are page 982 and 983.
The interpreters kindly ask the witness and counsel, prosecutor, to pause between question and answer. Thank you.
Yes.
Sorry.
And starting at line 24 on page 982, according to the testimony of Mr. Inayat, he stated, "I have to point out that when we had started this search and seizure, we had expected that hopefully we will be able to describe in detail each and every piece of document that we are going to lift. But by midday, we had realized that the sheer amount of documents that we were going to seize will not make that possible. So, as the folders and the books and the documents were being brought to me, I would register them on the evidence register form and I would take custody." So, in fact, detailed inventories were not compiled because by midday you realized there was no time to do so. Is this correct?
Well, that may be what Mr. Inayat realised at the police station. But I was also in conversation, not only doing the seizure at the municipal building, I was also in communication with the general in charge of the military, who was saying that he was getting concerned with the crowds that were building up in the street. Now, whether I got a message back to Mr. Inayat or not at that particular time, I can't remember.
Okay.
But that could be what the decision that Mr. Inayat took at the police station. And I mean, he was the team leader and evidence custodian at the police station,
yep.
And he had his own independence there.
And the result of this decision was that the person from which the documents were taken in the various locations did not have a detailed inventory to sign at the search premises, an inventory page by page. Is this correct?
No, that's correct. They got that the next day, and I don't think they got a page by page inventory. That would have been impossible because we seized, and again, I'm going back to my memory, I think for Priador, tens of thousands of pages of documents. So, for example, what we would do on the inventory, if there was a lever arch folder that had a heading, or a description of what the lever arch folder, maybe duty rosters for 1992 at Cosarats Police Station. That's how we describe it.
Yeah.
We may have said there was 20 pages in that lever arch folder. I can't recall now.
You don't
But it
recall
would have
that?
been. I can't. No, not
No.
now. I can't. No. But I do know that what we were doing is, you know, as I said, with the lever arch folders, if it was duty rosters at Cosarats Police Station or at Priador Police Station, that's how we would describe the documentation, so that the people that were responsible in the police station knew the documents that we were taking, types of documents that we were taking.
You described the folder, the batch, is this correct?
Correct.
Yes. And the persons from whom the documents were seized, they were not given an opportunity to make a representation of what the contents of these documents were, the contents of each of the folders that you described. Is this correct?
The individuals, and I don't know about the police station.
Yeah.
I don't know whether the chief of police station was there the entire time, but I do recall that I spoke with the mayor, who was responsible for the municipal building. But as I said to you on Monday, we had police officers from Republika Srpska who were also within our search teams. So they knew exactly what we were doing and what we were taking.
Yeah, they were present while we were doing, while you took the documents. They were not given an opportunity to describe the contents of each of the folders that you had taken. Is this correct?
No, that's correct.
In fact, I would like to refer to the testimony of Mr. Inayat in this respect, and this is the transcript IT 9936 T1008 to T1104, and I would like to refer to page 1061. So. Here, answering to a question of the council, which was at line 6. Understood. One moment.
Okay.
I'll move on. So I will move on from this reference. So the person who received the documents were not given an opportunity to inspect and confirm page by page what each page contained in each folder was. This is correct.
From my memory, that's correct, yes.
Okay. And you agree that in the particular circumstances, this was totally in line with the guidelines that the OTP of the ICTY had identified as an appropriate working method to carry out this search and seizure operation?
The standard was that you would do the inventory at the premises with the people concerned. But then, as I've said, you have to go with what the best advice is. And so that's what we did. We left the premises, we did the inventories back at the military headquarters and brought the inventory back.
Yes. And you adapted your guidelines to the specific circumstances of the case. Is this correct? You did not consider that this would affect the authenticity of the evidence you were seizing. Is this correct?
The authenticity is a different question, but I don't believe that it affected the chain of custody of the documentation.
Thank you. And for example, for a batch of documents consisting of about 1,000 pages of single individual documents, you would agree that, based on your experience, it would take at least 2 minutes per page to compile a rough inventory, wouldn't you?
Yes, if they're individual documents. But if it's a 30-page report or something like that, then you can put that into an inventory. Or if it's in a lever arch folder or an envelope or something like that, that's got a description on the front, you can do your inventory in that way.
Yeah, and let's imagine a document of 1,000 pages of individual documents, similar to batch 1, for example. Now, it would take about minimum 2 minutes per page to provide a vague, rough description?
Probably. I don't know. But I mean, batch 1, as far as I was aware, was letters and attached witness statement, witness names, etc., etc.
Yeah. Now, if my math is not wrong, that would require about 2,000 minutes to provide an inventory, which corresponds to more than 33 hours. You would agree that it would be problematic to prolong a search and seizure operation for 33 hours in order to make a detailed inventory of each page on the spot, would you not?
Yes, and that's why we did our inventories the way that we did.
Thank you. And one of the reasons why a detailed inventory could not be done on the spot would be, for example, if a large part of the materials would be in a language that the staff who carries out the operation does not understand. Is that right?
That's why you would take a language assistant with you. And that's what we did on every search and seizure mission that we had. We had just as many language assistants with us as we did investigators, lawyers, searchers, etc.
And in fact, in your search and seizure operation of 97, investigators were not in a position to describe all relevant materials in the BCS language on the spot. Is this correct?
I wouldn't really agree with that, because we had language assistants that were with us in the police station and the municipal building. And they were able, if we decided, okay, what is this particular cupboard, for example, what's in this cupboard, they would quickly go through folders, lever arch folders, envelopes, whatever it was, and give us a quick assessment of what the documentation was. And then we would make the decision as to whether we would take it or not.
Yeah.
But the language assistants play just as big a role as what, if you can say, the searchers play.
Yeah.
Because you're quite right. I mean, I didn't understand the BCS language.
Yeah. So in order for a detailed inventory to be provided in a language that the person who sees the documents does not understand, that would be necessary to have a third person, the interpreter, to look page by page into the document, to translate page by page the contents of the document so that the detailed inventory can be made. Is this correct?
We had many language assistants with us. It wasn't just one that was doing that particular work.
Yeah.
You know, we would have on each of the teams a number of searchers, and I think there was probably exactly the same amount of language assistants that was working with us.
Yeah. And this was an operation that was planned, you told us, way in advance, weeks in advance. Is this correct?
Weeks in advance, yes.
Yeah.
Correct.
And if a search and seizure operation had to be carried out under time pressure, that the availability of numerous interpreters, that could be problematic. Would you agree with that?
It could be.
Now, when you carried out this search and seizure, you told us that on the next day you went back to the authorities from which you seized the documents and you provide them with a better inventory. When you provided them with the inventory, you didn't bring back the documents for these authorities to check that your inventory was accurate, did you?
From memory, no, we didn't.
So you just delivered the document that you yourself had compiled. They could not compare what you had written with the documents that had been seized the day before. Is this correct?
That's correct.
So in fact, the person from whom the documents were seized were not able to verify whether the detailed inventory that you had provided did correspond to the documents that had been seized.
Correct.
Now, you told us in the course of your testimony of the 24th of January 2022 that in certain cases you even provided back to the authorities from which the documents were seized scanned copies of the documents that you had obtained, for example, administrative files concerning military personnel. Now, these were documents that the authorities from which you were seized them were authorized to possess. These were their documents. Is this correct?
Yes, they belong, for the type of documents that you're referring to, they belong to the military, the Army of Republika Srpska, yes.
Did you understand that one of the purposes of the search and seizures that were carried out on the 8th, 17th, and 22nd of September was to deprive the accused of the possession of the documents that were seized? Did you understand that?
Yes, I fully understood that, yes.
Now, with this in mind, would you agree that providing copies or information on the materials that it's alleged that the accused were not entitled to detain would run contrary to the purpose of the very purpose of the search and seizure? Do you agree with that?
Yes, but I think you could give them a generic list of what you had taken without giving the specifics.
Thank you. Now, in paragraph 14 of your report, you write, as the documentation was seized, it was recorded on the relevant forms, photographed and or videoed, placed in evidence bags, and then into evidence boxes. Are you sure that this is the procedure that was followed?
It was at the municipal building, yes.
And the same way that you were sure that there were 4 locations searched, 3 locations searched?
No, I was in charge of the search and seizure at the municipal building, and I can categorically say that that is what we did at the municipal building, is that as documentation was taken. Now, whether they were put directly into evidence bags or whether they were put into boxes, I can't recall now, but they were definitely, documentation was bagged up as the documentation was seized.
In fact, on the 24th of January, in paragraph in page 3224 of the transcript, lines 15 to 18, you stated down, I can't recall now whether we were using evidence bags. I do know that when we got back to Zagreb, we had boxes, but it could have been that evidence bags were put into the boxes. So you don't really recall whether evidence bags were used or not used. Is this accurate?
But that's what I just said.
But you wrote in your report, as the documentation was seized, it was recorded on the relevant forms, photograph, video, placed in evidence bag, and then into evidence boxes. So in fact, you don't recall whether they were placed in evidence bags, do you?
That's my recollection, that they were placed into evidence bags. But again, you know, as you said, it's 24 years on.
Exactly.
It was either into evidence bags and or evidence boxes.
Well, in your report you say and then into evidence boxes.
Yes.
And on Monday you said, in fact, you don't recall whether there were evidence bags. So can we agree that you don't recall whether evidence bags?
I agree.
But you wrote, nevertheless, that they were placed in evidence bags.
That was my recollection at the time, yes.
At the time when you wrote your report, was your recollection?
That was my recollection when I wrote the report, correct, yes.
And in the last days, you gained a better recollection. So you have some doubts about your recollection.
No, I don't have any doubts about my recollection. I mean, that is what I believe that we did, at least at the municipal building, that we used evidence bags, and those bags were placed into evidence boxes.
But you are not sure about that.
Look, I really can't answer you. I can't take it any further than what I've already said.
So is your testimony that you can't be precise on this, correct?
I can't be 100% certain, correct.
Okay. You also state that the documents were photographed and videoed. Are you sure the documents were photographed and videos before they were placed in evidence boxes?
I said and or videoed, I believe.
Okay. Are you sure that there was this kind of like photographic documentation of
Yes, at the municipal building, yes, we were taking photographs.
And this would only apply to the one building you were in. You can be sure that this was done, for example, in the location where Mr. Inayat carried out the search and seizure operation.
Because I wasn't there.
You weren't there, so you cannot say what happened there.
No.
No. And
No,
if
Could the speakers kindly not overlap, because the pace and also the overlapping is making it very difficult to get an accurate interpretation of the court proceedings. Thank you.
After your question, and Mr. Reid, you pause before you answer the question.
Sorry, Your Honour, yes. I went to the police station in the early morning and I served the search warrants on the acting chief of police, I think he was at the time. And then I left the police station with the police officers who'd been allocated to carry out our search. And I think we just walked across the road. I think the municipal building was within walking distance of the police station. And I never went back to the police station. The next that I spoke with Mr. Inayat was when we were back at the headquarters in Banja Luka.
Okay. But you were coordinating, you said, the search and seizure in all the locations. So it's not something that you really checked whether in other locations documents were photographed or video recorded before taking them away. That was not one of the requirements you were paying attention to. Is this correct?
Not so much not paying attention to. I was paying a lot more attention to what we were doing in the municipal building. But if Mr. Inayat had had a problem, he would have got a message to me. Now, whether he decided that they weren't going to photograph and or video, I don't know. I can't recall now.
Okay, and you have.
But it would have been a decision. He had his own independence.
Yeah.
He's an experienced investigator, and he had his own independence as to what he would do at the particular sites.
Because
particular site.
Ms. Bolici, you are still interrupting him while he's talking. Please wait till he finishes, and then you may respond.
I will, Your Honor. Apologies. Mr. Inayat had the autonomy to decide not to take photographs or not to video record the documents before putting them, before taking them away And this was, in fact, in line with the OTP search and seizure practices at the time. Is this correct?
He had the autonomy, yes. He had the independence to do what he believed was the best. If there was something there that was impeding him from doing that, or he thought it was slowing the process down and they weren't going to finish the search, then yes, he could make that decision.
Yeah, because not taking pictures of every single document at the premises would not affect the success of the search and seizure operation. Do you agree with that?
I agree in part to that, but taking photographs and or videos would be a lot better than not taking them. But no, it wouldn't affect the chain of custody of the documentation, no.
Thank you. Now, I would like to refer to the transcript of the ICTY testing of Mr. Inayat, and in particular to the document IT 9936 and T924 to T1007. And that would be page 983. And in particular to line 12. In referring to the process of the search and seizure that he conducted, he was asked, now, before the boxes were transported, were those boxes sealed? And he answered, I believe so, that the boxes were sealed, but the proper procedure for sealing the material was carried out later in the base. Mm-hmm. Now, do you recall that, in fact, the documents were taken away from the premises from which they were seized? They were inspected later on at a secure location, and then they were sealed with the proper procedure in order to transport the materials back to The Hague. Do you recall that?
Yeah, yes, I think what he's referring to there is, yes, the boxes were sealed at the police station or the municipal building. Then when we took them back to the military base in Banja Luka, they were unsealed. We did the inventory, which then also enabled us to do the movement records to keep the chain of custody. And then once all that was done, the documents were resealed in the boxes and transported to Zagreb.
Yeah. So once you took away the documents from the premises, you had to inspect them first, and then after that, you sealed the documents in order for them to be transported. Is this correct?
No, what I said was that the documents were sealed at the premises for, let's say, the municipal building. The documents were sealed, which makes me think there's either evidence bags and or evidence boxes. Then when they arrived at the military base, we unsealed them, worked through the night with the language staff to do the inventory, were able to do our movement records to keep the chain of custody on the documentation. Then they were resealed and ready for transportation to Zagreb, yeah, where they weren't unsealed again until they got to The Hague for processing.
Yeah, and between the moment when you took the documents and the moment when you transported them away, you did have to carry out an inspection of these documents. Is this correct?
Yes.
Now, you state in paragraph 14 of your report that the documents that were seized were all seized under COC. Do you mean that all the seized documents received a stamp, a classification indicating that the chain of custody procedure had to be observed? Is this correct?
No, the chain of custody is a process. It has nothing to do with the stamping. What you would do is on the metadata, you would say that we have dealt with these documents by way of chain of custody. We would then provide to the evidence custodian or the head of the evidence unit, our evidence unit, the documentation which shows an unbroken chain from the minute we received it to the minute that it gets to The Hague, to the evidence unit. Then they would say, yes, okay, there's no unbroken chain, that is chain of custody, and then they would be processed. The stamping doesn't show whether it's chain of custody or not. The location shows that it's chain of custody. We used to have what we called an evidence day forward vault, which was on the second floor of the ICTY, and the chain of custody vault was on the third floor. And any documents that were dealt with as chain of custody went into that particular vault and had a special way of being treated, if I could put it that way.
Yeah. So really what matters is how the documents are handled and not whether they are labeled or not labeled at the time as they are seized as COC or not COC. Is this correct?
No, you've got to have your paperwork in order. And that was what we would have been doing also when we were doing the inventories, to say, okay, these documents have never left our custody. From the minute they left the municipal building, they have been in our custody. From the minute we get to the military barracks, they stayed in our custody. When they were transported from the military barracks in Banja Luka to Zagreb field office, they were in our custody.
Yep.
And then that's why we made the decision to drive them from the Zagreb field office to The Hague, so that we maintained the chain of custody. They didn't have to go into the hold of an aircraft or whatever. Yep. So that the chain of custody remains unbroken the whole way through. And
Yep.
the paperwork reflects that chain of custody.
Yeah. So it doesn't really matter whether the document is stamped or classified as COC or not COC. What matters is that you are able to say these are the documents that were seized. Is this correct?
I don't fully understand the question.
Yeah, I will clarify. So in the course of his testimony, of the testimony of Mr. Inayat, he was requested to provide some of the forms that were used to describe the evidence, and
Yes.
he provided 4 examples out of these thousands of documents. And if we look at the transcript of the 29th of January 2002, and I'm referring to the document with year end IT 9936, and it's page T1008 to T1104, and the relevant page is page 1063. He answered to a question in relation to one of these forms. In line 13 from the Defense Counsel, who asked, now another thing that I see on this form, if you go down into kind of the second section of the form, where it has type, language, date, things of that nature, yes? There are designations across there. Chain of custody, no. What does that mean? And the answer was that the document was not seized under the procedure of chain of custody. That's what it means. Had it been seized under chain of custody procedure, then the answer would have been yes. So, first of all, like, not all of the documents that were seized, would you agree, were marked as COC documents. Would you agree with that?
That may well be the case. I can't recollect that specific portion of Mr. Inayat's testimony, but if that's what he says, that it was marked not chain, and as I said to you on Monday, we used to have the tick boxes and the check boxes. So if it wasn't checked as chain of custody, then no, it wasn't treated as chain of custody.
Mr. Cadman.
Just being indicated that they're not receiving translation.
Zotë gjykatës nuk ka për kthejmë presja kanиш me
Your Honor, there was no interpretation from the moment when the question by the prosecutor started.
Po, që tash po.
Now, yes.
Could we repeat the question for the benefit of Mr. Haradinaj?
Yes. So, the question was, starting from the quoting of the page, Mr. President, the entire quote. I should read, yeah. Okay. Yeah.
So first of all,
yeah.
at line 1.
Yeah. So the question was, so first of all, not all of the documents that were seized, would you agree, were marked as COC documents? Would you agree with that? And the answer was, that may well be the case. I can't recollect that specific portion of Mr. Inaya's testimony, but if that's what he says, that it was marked not chain, and as I said to you on Monday, we used to have the tick boxes and the check boxes. So if it wasn't checked as chain of custody, then no, it wasn't treated as chain of custody. That would be sufficient?
Yes.
Thank you. Now, Mr. Reid, in the course of your testimony of the 24th of January 2022, you highlighted that based on the year-end ranges of the batches, batch 4 was stamped first, and then batch 2, and then batch 1. Is that correct?
That's correct, and that was purely and simply by the ERN ranges that I could see.
Yeah. And if, based on the ERN numbers, you would conclude that batch 4 was stamped prior to batch 2, and batch 2 was stamped prior to batch 1. Is that correct?
Correct.
Yeah. Now, if the documents were registered into evidence on the same day, that would provide an explanation to the year-end ranges that the batches were given. Is this correct?
That's correct, but I don't have any information on that.
Yeah, it would simply mean that the evidence bag that contained batch 4 were opened before and stamped, and then the evidence bag that contained batch 2 would be opened next and stamped, and then the evidence bag that contained batch 1 were opened last and then stamped. Is this correct?
That could be a possible explanation, yes, yes. But I don't have any of that information.
So you have not been provided with any paper documenting that the submission of the evidence bags containing batch 1, 2, and 4 were submitted into evidence on the same day. Is this correct?
No, that's correct.
And that evidence bags were open and then documents stamped, and that a certain ERN had been attributed to documents contained in each evidence bag. You have not seen such documents. Is this correct?
No.
Had you seen such document, you would be able to provide an explanation on the range of the year ends you talked about. Is this correct?
Yeah, that's correct. I mean, it was just an observation that I made on Monday, that it just seemed strange that they were stamped out of order. But it was just an observation, that was all.
Thank you. Now, I would like to move to paragraph 23rd of your expert report, and this is the document is on page DNH 0865. Now, you suggest in this paragraph of your report that for every witness name included in the confidential documents, the SPO should have identified in the course of the proceedings its status as active witness, protected witness, deceased witness, hostile witness, not to be called as a witness, or unable to ascertain the status of the witness. Is this correct?
Yes, again, it's not something that I'm saying that you should do. It's something that I would have done. And I was asked, what would you have done in this situation? And that's what I would have done. Okay. Is I would have, and I think it related mainly to batch one, in that there were SITF and SPO, if I can call it, requests for assistance. And in many of those requests for assistance, there were large witness lists. And I would have gone through each and every one of those witnesses, and where I could have, would have put a classification there.
Okay. And in your experience, in the course of a confidential criminal investigation, if a witness provides evidence to the prosecution that is not particularly favorable to the case theory, that is not a reason why the witness statement is no longer confidential. Would you agree with that?
I agree.
And you would not consider a witness statement as public for the sole fact that the witness is hostile to the prosecution, right?
Correct.
And in the same way, you would not consider witness statement as non-confidential because the prosecution at a certain point in time might be inclined not to call that witness to testify. Is this correct?
That's correct. But again, the reason that I'm saying this is it was my understanding as well that the parties, and I believed at the time the trial panel, were not going to get access to any of this documentation. And that's why I said it's imperative that, well, not imperative, but I would go through each and every one so that people can see and there can be some confidence in relation to the witness list, that we know exactly who we've got. If we've got 100 witnesses, 5 may have never been located, 5 may be deceased, 20 may be hostile, 10 may have protective measures from the ICTY, for example. So I would go through. That was the point that I was trying to make in that paragraph.
So you're making a comment on the amount of information that, according to you, had to be disclosed. Is this correct?
It's not on what had to be disclosed. It's trying to give as much information, credible information, as you possibly can, rather than the sampling process.
Now, you have been provided with the declaration of the investigator, which is P0090 red. And if you move to the annex to this declaration, you'll see there is a table where the documents that were contained in batch 1 were described. In particular, I would like you to move to page 095537. Yep. Now you see that in the last column on the right, it's indicated names of potential witnesses, yes, no. And this information is provided document by document, page by page. Do you see that?
Could that be blown up just a little bit for me, please? I can't see. You say it's 3.7. I have a copy of that here.
Yeah. Just to refer to the table, you can see that the table is organized.
Atëherë mendoj që mund të shikoni që tabela është organizuar në mënyrë të tillë që
Can we go again, start over with that?
Yeah. So you see that in the last column of the table,
Yes.
there is an indication of whether names of potential witnesses are included, yes or no. And this is an indication page by page, document by document of the documents included in batch 1. Do you see that?
Yes, I see that, yes.
Okay. Now, if we go back to page 095533, the first page of this document, and you look at paragraph 3 of the declaration, you'll see that,
yes,
as explained by the SPO investigator, the chart of batch 1 contains 9 columns, 6 of which reflect the categories of information required by the decision on disclosure of certain documents seized from the KLA War Veterans Association. And there is a reference to a judicial decision on the disclosure of this document. Now, you understand that the scope of the information on the confidential documents that has been provided to the accused has been determined by way of a judicial decision. Did you get this information from the materials you had reviewed?
Yes.
So in fact,
yes, I gathered that, yes.
So in fact, your opinion concerns like the amount of information that had to be disclosed and is not comment on the SPO practices. Is this correct?
It's just, it was a comment on what I would have done. And as I said before, if I had 100 witnesses in the annex to a request for assistance, where I could, I would have gone through every single one of them and given them a classification.
Now, you agree that all witnesses who provide evidence to prosecution authorities enjoy the same degree of protection regardless of the assessment on the quality of the evidence they provide. Do you agree with that?
Yes, I agree with that.
And in paragraph 23 of your report, you also state that deceased witnesses should have identified as such. Now, have you verified whether the SPO has in fact taken such a conservative approach and not considered deceased witnesses when providing information whether a witness name was included or not included in a certain document of batch 1?
If I understand your question, I mean, as I said earlier, deceased witnesses should also be given the protection. Just because a deceased is dead, I mean, there could be repercussions on the family.
So if the SPO in a a conservative approach, in a pro reo approach, would have decided not to even consider the names of deceased witnesses as witnesses whose confidential name appeared in the relevant documents, or would have decided not to consider the names of persons who had refused to cooperate with the investigative authorities. You would consider this like a conservative approach in terms of identifying how many witness names, or if witness names were included in each document. Would you agree with that?
I don't fully understand the question, but what I'm saying here is that I think if you can classify the particular witness into a category, then I think that's as important. And that's the only comment I was making. And it was made in the context that it was my understanding that the parties and the trial panel, and I don't know whether I'm correct or incorrect in this assumption, was not getting the documentation, if I can put it that way.
Yeah.
So I would try and feed in as much information as I possibly could.
Yeah. And your opinion is that even a witness who is deceased still enjoys the protection of confidentiality in the course of confidential criminal investigation. Am I right on that?
Yeah. Yes, in that, the deceased witness should get that protection, but more importantly, the family of the deceased witness should get that protection.
Thank you. Now, Mr. Reid, I would like to show you document with the exhibit number P00092 red. Now, this is an official note on the seizure of the documents on the 8th of September 2020. Have you been shown this document at the time when you wrote your report?
No.
You have not. Now, I would like just to point to you to paragraph 12 of this document, when it refers to the placing of the documents in the evidence bags. Now, would you agree that in order to provide an assessment of any chain of custody issue, looking at documents like these ones would have been helpful for you to provide an informed opinion?
I'm sorry, I'm sorry, I was just reading that paragraph. I hadn't finished reading the paragraph. Actually, I think I have it. I think I printed it out from the documents I got from you this morning. Yeah, I've got it here, sorry.
Yeah.
Yes. Yeah, I've read that now, paragraph 12. Thank you.
Information like the information provided in this document would have been helpful for you to carry out an informed assessment of whether the procedures carried out by the SPO were in line or not in line with the alleged best practices. Is this correct?
That's correct, but I'm just not reading that paragraph. When were these documents handed out? Were these at the War Veterans Association or back at the SPO premises? Because it appears as though it's handed over at the field office because they were then put straight into a safe.
Mr. Reid, would the document that describes the handling of the seized materials, would such a document have been of assistance for you in the task of challenging the SPO practices on the search and seizure operation? Would you have needed to look at such documents?
The whole document would have been very helpful, yes.
But you didn't have the document.
Not when I wrote the report, no.
You didn't ask for it.
I didn't know it existed.
And I would like to show you another document, which is P0099 red. Now, if you look at these documents, this is the receipt of documents concerning batch, official note documenting the receipt of documents from batch 4. If you look at paragraphs 5 and 6 on page 083987, if you look at the information included therein, would you agree that this is the kind of information that you would need to review in order to be able to assess whether procedures were followed or not followed by the SPO?
Yeah, this is another document that would have been helpful. But as I said, I think in the report, I didn't necessarily think batch 4 fell into the chain of custody. This was sort of a media outlet saying, look, you know, we've got this type of documentation, and they handing over the documentation as opposed to a judicial order,
yeah,
or a search and seizure warrant or something. So, but no, that would have been helpful as well.
This is the kind of information we need to have to review in order to assess whether procedures are followed or not followed. Is this correct?
Sure, and I mean, if there's similar documentations for batches 2 and 3, that would have been helpful as well.
And you didn't have such information?
No.
So when you provided your expert report, you actually were not fully informed of what was the procedure that had been carried out. Is this correct?
That's correct. I mean, as I said, I think in one of the first paragraphs, I outlined the documentation that I relied upon. I didn't even have the declarations of the investigator to rely.
So at the moment when you assess that the SPO did not follow the correct procedures, you are in fact not shown any documents that documented such procedure. Is this correct?
No. Look, I don't think I said that the SPO didn't follow the correct procedures. What I said was this is what we would have done at the ICTY. And then it's up to, you know, that was my assessment.
Yes, and when you gave a comment on what SPO procedures looked like, in fact, you had no documents that would enable you to assess what procedures had been followed. Is this correct?
I had the public transcripts, which gave me a little bit of an idea. I think if I read the transcript of the investigator correctly, she brought back on the 25th of September, I think it was, one evidence bag of batch 3. But again, that's all I got. I just got, okay, she brought that batch back, but I didn't understand how she got the bag of evidence to bring back.
Yeah. The Defense Counsel did not make available to you the documents that were provided to them. Is this correct?
Yes, Mr. Cadman.
I do object, Your Honour. Mr. Reid was provided with what we were permitted to provide him with at the time. The suggestion that documents were withheld from him, these matters were not in evidence at the time that he was instructed as an expert. Your Honours will recall that we made an application. We tried through inter partes communications to get agreement on what he could be provided with, because it was not clear at that time. That the SPO refused to engage on that. And so what we provided the expert with at the time were the transcripts of the testimony of those officers who have given evidence. And that's the basis upon which he gave his report.
Thank you. Your objection's overruled. Go ahead, Ms. Bellucci.
Yeah, just for the record, in response to what Mr. Cadman just said, the SPO has never made any determination on what counsel should have provided or not provide to his own expert. In any event, Mr. Reid, just to conclude it, no documents were provided to you that would enable you to assess which procedures were followed by the SPO. Is this correct?
As I said, some of the documentation was able to assist me partially, but the documentation that you've shown me here would have been quite helpful as well.
Thank you, Your Honor. I have no further questions.
All right. Mr. Cadman, do you wish to re-examine the witness?
I would just like to take 5 minutes, if I can, to consider.
Mr. Cadman?
Your Honour, I don't have any questions as such. I just, all I would like to say, the trial panel may be aware, I just wanted to congratulate Mr. Reid on, he has recently been awarded on Australia Day, the Order of Australia for significant service to international criminal investigations. So just to put on record to formally congratulate him, and I'm sure the trial panel will as well.
Thank you, Mr. Cadman. We did read that, and of course, Mr. Reid's reputation is well known. So thank you. Congratulations, Mr. Reid.
Thank you, Your Honour. Thank you, Mr. Cadman.
Thank you, Mr. Cadman. Ms. Bellucci.
Thank you, Your Honor. I would like to request admission into evidence of some of the exhibits that have been shown to the expert witness, and this is in particular the video with ERN 10-47-2901 and the corresponding transcript 104-72901 TRET, as referred to in the course of the witness testimony and relevant and probative. As well, I would like, in relation to the instructions provided by the trial panel today, also to seek admission of the public trial judgment ICTY IT 0484T of 3 April 2008. This is the trial judgment in the Haradinaj et al. Case, and the SPO has provided a PDF copy of the judgment to all parties on the registry prior to the commencement of the cross-examination. And finally, I would like to request admission of the transcripts that have been referred to in the course of today's examination, and these are the documents with the following numbers: IT 9936, T1008 to T1104, IT 9936, T3750 to T3822, and IT 9936, T924 to T1007. And all of these materials is public.
Wish to be heard, Mr. Cadman?
Your Honour, we maintain our objections that we made on Monday. As to the relevance, Your Honour has already ruled. We repeat the fact that the matters that relate to historic events are not relevant to these proceedings, and so we maintain the objection in respect of those matters that relate to the historic matters.
Thank you. Mr.
We
Bowden?
would support those objections.
All right. The court will rule on the tender later on.
I think Mr. Rees would like to add his...
Oh, Mr. Reed, I'm sorry. I didn't mean to ignore you. Go ahead.
No, there was nothing that I wanted to say, Your Honour. No, nothing.
No. Mr.
Oh, Mr. Rees, sorry.
Mr. Rees. I said Mr. Reed.
Sorry.
Mr. Rees. Turn your microphone on, Mr. Rees. Are you getting anything? Can you text to each other, Mr. Bowden?
I can.
Perhaps you can find out what it is Mr. Rees wants to say, because we're not hearing him.
Yes, if the technology is not with us, I will endeavour to do so.
We can wait for a moment. While they're doing that, Mr. Cadman, did you have something else?
Yes, I haven't formally requested for Mr. Reed's statement report to be entered, and of course there is the only additional exhibit as part of the presentation queue is the ICTY manual, and obviously we request that that is exhibited as well.
And as to your additional admission tendering, we will rule on that at the same time as the other offer. Let's wait just a minute, Mr. Cadman, until Mr. Rees has an opportunity to weigh in. Mr. Rees, it's suggested that you sign out and sign in again.
Your Honour, whilst we're waiting, if I may turn my back for a moment just to consult with Mr. Haradinaj on one matter.
Of course.
Your Honour, I have followed the court officer's instructions, and I hope you can hear me now.
We can hear you now.
Thank you. And I'm grateful to the
You might turn up your volume just a bit.
Well, I would request further assistance from the court officer in terms of volume in the courtroom.
You're okay now. Go ahead.
Thank you, Your Honour. Just in relation to the proposed admission of the documents that Ms. Bellucci referred to, My submission would be that none of those items can be properly produced through this witness. To the extent that he has any personal knowledge of the matters referred to therein, he's been asked questions about that, and his answers are the evidence that he can that can be relied upon and can be produced through the witness. In relation to the items themselves, this witness gives no evidence as to their provenance, nor has any personal knowledge of the contents of those items over and above the matters that he has addressed in his own evidence.
Thank you. We will take that into consideration. We'll rule on all the offers or the tenders later today or on Monday.
Thank you, Your Honor.
We have some questions from the panel members. We'll begin with Judge Metro.
Thank you, Judge Smith, and good morning to you, Mr. Reid.
Good morning, Judge.
I'd like to ask you about something you were asked on Monday. You were asked a number of questions by the counsel for the SPO regarding your experience of witness intimidation linked to cases you dealt with in regard to the Kosovo conflict. Do you remember those questions?
I do, yes.
Can you tell us how, if at all, this climate and environment of intimidation, which you described, impacted your work as a prosecutorial office, in particular in respect of your ability to investigate and prosecute?
Your Honour, as far as the investigation's concerned, we were able to protect the information until such time as an indictment was laid. It was at that stage, and I think the prosecutors in the three cases that we had would all agree with me, was when our problem started. And when things became public, and as I said, witnesses would either just refuse to give evidence, and the example that I gave of one of the witnesses attending the court in The Hague, sitting in the witness box, refusing to give testimony, being told by the presiding judge that he would be charged with contempt of court and possibly jailed, he took that option rather than give the evidence before the court. So it was a very, very difficult. The Kosovo cases, all the Yugoslav cases were very difficult, but the Kosovo cases were particularly difficult.
And I think you just mentioned three cases. Do you remember which three cases were affected by these issues?
There are actually two cases. I think the first one was Limai, the second one was Haradinaj, and then there was a retrial in Haradinaj. And we had problems in all of those cases, in the prosecution side of the case. That's not a criticism of the prosecution. It was just very, very difficult.
Now, in such an environment, and again, in your experience and opinion, how damaging would be the leak of information pertaining to your witnesses in terms of your ability to fulfill your mandate, that is?
It's very difficult. And I mean, we had procedures in place that if it got to a stage, and I can't now recall whether it did get to a stage, but we had evacuation procedures with KFOR, the Kosovo force, the military, to evacuate witnesses and their immediate families from Kosovo to a safer environment. The difficulty with Kosovo is that in some instances, if you're working, say, in Australia, the nuclear family could be just 3 or 4 people that you have to extricate to protect. In Kosovo, it could be 50 to 60 people living in one compound. And that also impacted upon the work that we were trying to do. But it was very difficult. We did have procedures in place to evacuate. And again, I can't recall, I just have at the back of my mind that we may have used that procedure once to evacuate a particular family related to a witness.
Maybe my question is a bit of a hypothetical, Mr. Reid, but in such a context, how concerned would you be if protected information regarding your witnesses was to leak? It was to be made in the public domain through unauthorized disclosure. How concerned would you be as a prosecutor?
I'd be very concerned, very, very concerned.
And can you tell us why?
Leak of any information is detrimental to a prosecution's case. The leak of witness information is doubly detrimental in that it not only impacts the potential of your case, but it impacts on the psychology of the particular witness. And if it's found out to be, if the witness community find out about it, it also impacts upon other witnesses. So, you know, if 10 other witnesses find out about it, there's a huge impact on your case. You don't just have one witness who you've got to be concerned about now. If it's leaked and it becomes public knowledge, then you've got 10 to say 15 to 20 witnesses who it impacts upon.
I want to ask you about something else, Mr. Reid, and I'm not asking you to disclose any confidential information, so you can keep it at a relatively generic level, but did your office, the Office of the Prosecutor of the ICTY, cooperate with the Republic of Serbia in relation to the investigation of some of your cases?
Yes, we did. The cases that I've just referred to, yes, we cooperated with the Republic of Serbia. We cooperated with the Republic of Serbia on many things: Kosovo cases, fugitives, etc., etc.
And did you seek and obtain information from the Republic of Serbia in the context of that cooperation?
The type of evidence that we were looking for was the linkage evidence, which would come from the authorities. They had quite a lot of information in relation to the crimes on the ground. They had quite a lot of information in relation to the specific witnesses, but the types of information that we needed was the linkage. For example, military signal intelligence, what the Serb forces were finding out, what the Kosovo forces were doing, who were the commanders in the field of the Kosovo forces, etc. And that was material that was lacking.
And forgive me for asking you the obvious, maybe, Mr. Reid, but in the context of that cooperation, did you get to pick or to handpick the Serbian officials with whom you were dealing, or were they designated by those authorities?
In some instances, they were designated by the authorities. But we also had a good working relationship with a number of the authorities from our work in the tracking down of fugitives. So we were able to speak with them as well, but they weren't able to get us the information that we required either.
And in that context, did you have any dealings with Mr. Vukcevic and his deputies?
Mr. Vukcevic was the war crimes prosecutor, and we dealt with him on many issues, but Kosovo as well, yes.
And did you feel that as a result of your cooperation with Serbian authorities and Serbian officials that your investigations were being compromised in terms of their independence or impartiality?
I wouldn't say that they were being compromised. I mean, with Mr. Vukcevic, in defense of him, he did everything he possibly could to assist us. And in some instances, he was hindered by authorities behind the scenes at his own government, I believe. But yeah, the investigations were compromised by the fear and the intimidation that existed in and around those investigations and prosecutions.
And maybe about the information you receive from Serbian authorities, but in general, as a experienced police officer and member of a prosecution office, when you receive information from a particular source, do you take it at face value, or would you consider its weight, verify it, further investigate it, and try to corroborate it before deciding whether to use it or not? Would that be fair?
Yes, I mean, that's a very fair comment. You always try and corroborate, whether it's a crime-based witness, or whether it's a linkage witness, a high-profile witness, you always try and corroborate. And you can corroborate through other witnesses, you can corroborate through documents, public source material, etc., etc. But where you can, you should always corroborate the testimony of every single witness.
And as again in your practice and experience, whether in Australia or at the ICTY, did that happen that you collected information from individuals you suspected of having committed a crime?
I mean, yes. I mean, in some instances, I mean, this was the one of the difficulties that we had, that in some instances we would be investigating one perpetrator group and we would have a group of victims, but then there was another team investigating the victims, which were their perpetrator group, and the victims were the other perpetrator group. If you get my drift there, is that yeah, we had problems there, and that occurred a couple of times, or number of times, where perpetrators would give evidence or give information, and we would corroborate that and confirm that evidence, that it was in fact true and correct. And I mean, some of the best examples are the accused who plead guilty and then give evidence against up the chain of command. And for them, that had to be corroborated to the nth degree.
Well, I think you've answered my last question, Mr. Reid, but if and when you receive information from someone you suspect of involvement in the commission of a crime, you will take steps typically as an investigator or prosecutor to verify the credibility and reliability of that information. Would that be a fair proposition?
Yes, definitely.
Thank you. Those were my questions. I'm grateful. Thank you, Mr. Reid.
Thank you, Your Honor.
Judge Gaynor has some questions.
Thank you, Judge Smith. Mr. Reid, I have a couple of questions about standard operations procedures and guidelines, excuse me, or SOPG as you refer to them in your report. Now, you said in paragraph 9 of your report that SOPG were developed in the first few months at the ICTY. And as the office evolved, other procedures and guidelines were developed. And you list a sequence of SOPG at paragraph 10 of your report. Could you clarify when you would consider that those SOPG came into effect?
Well, they would have come into effect the minute that the deputy prosecutor would have approved them. So, for example, some of the very early standard operating procedures, we were implementing. Well, for example, the standard operating procedures on missions. We were going on missions from probably September, October of 1994. So they would have been implemented by then, because we were working to those procedures on how to go on mission, what you had to do, the reports, the reporting conditions. The standard operating procedures on, say, search and seizure, when we went into Priador and did the crime scene examination, we had a search warrant then, and that was in February 1996. So as early as February 1996, they would have been implemented. I can't give you an exact date, but they evolved, and as we saw a need to standardize our procedures, we would then write procedures to be implemented.
You emphasize in paragraph 12 of your report that it is imperative that staff not only know about the existence of the SOPG, but it is equally important that they understand their meaning and how to implement them. And you go on to draw a distinction between the period before the year 2000 and the period after the year 2000. Focusing on the period after the year 2000 until you left in 2018, what mechanisms were in place within the OTP to diffuse those SOPG to staff within the OTP?
Rather than be doing face-to-face inductions, which we were doing prior to 2000, there was a handbook that was given to new staff members. Staff members were put with more experienced staff on trial teams, for example, because we were running a number of trials post-2000. They were put with experienced prosecutors, experienced investigators. Plus, we also had an induction form, if I can call it, where the staff member had to acknowledge to the Chief of Investigations that they had read the induction booklet, or the handbook, if I can put it that way. I remember one of the senior trial attorneys, Mundus, and one of the trial attorneys, Vladimir Tochilovsky, were very instrumental in putting those types of material together for the information of staff members.
And would you say there was any mechanism in place to ensure compliance by staff within the OTP with those SOPG? Was there any formal compliance mechanism in place?
The formal compliance came from the observations of the senior trial attorneys, of the team leaders, and in some instances it would be brought to my attention. But overall, majority, and I'm talking very high 90s%, complied with the procedures.
All right, fair enough. Thank you very much, Mr. Reid. Thank you, Judge Smith.
Thank you, Your Honour.
Mr. Reid, that concludes your testimony. We appreciate your being with us these last 2 days, and we wish you well for the rest of your evening.
Thank you very much, Your Honour. Thank you. Thank you.
Before we take a break, I will deal with Mr. Reid's report, which you've offered already, Mr. Cadman. Ms. Bellici, you objected to paragraph 26, the second sentence of 27, the whole paragraph of 28, the last sentence and phrase in accordance with the RPE in paragraph 30. I'm sorry, the last sentence of paragraph 30, and then the phrase in accordance with RPE in paragraph 31. Anything else?
I think that's Your Honor. Thank you.
Mr. Cadman, any response at all? Those we've discussed them previously.
Well, our position is that the entire report should go in. He's given evidence on that. The prosecution's had opportunity to cross-examine him on those parts. We consider it all to be relevant, and none of it should be taken out.
Mr. Bowden?
No observations.
Okay. Having heard the parties, the panel admits the expert report in evidence except paragraph 26, the last sentence of paragraph 27, paragraphs 28 and 30, and the phrase in accordance with the RPE in paragraph 31. The panel notes that these paragraphs, these impugned paragraphs, contained impermissible opinions on the compliance of the SBO's search and seizure operations with the rules. In addition, paragraph 30 also contains comments that are not relevant to the topics addressed by the report. Given that this is an expert report, the panel orders the Haradinaj defense to submit by Monday, 31 January of this year, a redacted version, blacking out or removing the excluded paragraphs and phrases. It is this redacted version that will be admitted into evidence and become part of the record. Madam Court Officer, please assign an exhibit number to this report and state it for the record.
Your Honor, the exhibit report will receive number 2D12.
Thank you. 2D12 is admitted. And now as to the classification, Mr. Cadman, any ideas? Is this to be a public document?
Just to go back for a moment, the prosecution objection was to the last sentence of paragraph 30.
And the court has reviewed it and felt the entire paragraph 30 should be excluded. So do you wish this to be a public document?
Yes.
All right. Any objection to that, Ms. Bellici?
Not at this time, Your Honor. We will review further if there is any reference to names, which I don't think there is, but should there be any issue, we will address the court accordingly.
Mr. Bowden?
Nothing further.
Ms. Bolici, please have your answer to us when we come back from the break. We will take a break at this time.
I will, Your Honor.
Take a 45-minute break. Please be back here at 10:30, and we will continue to deal with the balance of our issues today. Mr. Cadman, did you have a question? Okay. We are adjourned.
All rise. All rise.
Be seated. Regarding the other exhibits tendered with Mr. Reed, the panel rules as follows. In relation to the ICTY Manual on Developed Practices, the panel admits this document into evidence as it is closely associated with the expert's report and was relied upon during his testimony. In relation to the video with ERN 104-72901 and paragraph 6 of the Haradinaj judgment, the panel understands that it is the SBO's case that the acts and conduct of the accused have to be interpreted in the context in which they occurred, and the SBO alleges that part of that context pertains to what it describes as an environment of witness intimidation occurred in Kosovo. This was put during cross-examination to both accused. The panel also notes that there are 2 charges in the indictment that are related to this matter. Mr. Reed was asked to testify as to his own opinion of the matter in view of past opinions expressed by him and in view of findings made by the institution of which he was an employee. The panel therefore considers that these items have probative value. The defense had an opportunity to re-examine the witness, so any prejudice of these items does not outweigh their probative value. It is further noted that the words uttered in the video are not recorded in the transcript of 24 January 2022, but the video has a corresponding transcription. The panel therefore admits the aforementioned video with its transcript as well as paragraph 6 of the Haradinaj judgment of April 3, 2008. The SPO is instructed to resubmit the excerpt of paragraph 6 of this judgment, which will be the only part admitted. In relation to the transcript excerpts of Mr. Inayet's testimony, the panel considers that these excerpts can only be admitted for the purpose of assessing the credibility of the witness and the reliability of his expert report. They are not to be relied on for the truth of their content. The panel therefore admits these under this condition. Madam Court Officer, please assign exhibit numbers to these items.
Your Honors, the ICTY manual will receive number 2D13. And then the document standard by the SPO. The video will receive exhibit number P165. The Haradinaj excerpt that will be uploaded will receive exhibit P166.
I'm sorry, did you say 66 or?
166.
And was the previous one 165 or 155?
165.
Okay.
And then, Your Honors, the transcript IT 9936 T924 to T1007 will be exhibit P167. Then the transcript IT 9936 T1008 to T1104 will be exhibit P168. And lastly, transcript with IT 9936 T3750 to T3822 will be exhibit P169. Thank you, Your Honors.
2D13 is admitted in evidence, as are P165 through 169. Ms. Bellici, do you now have an answer for us regarding the classification of Mr. Reed's report?
Yes, Your Honor, no objection to the classification as public of the document. Thank you.
The classification is therefore public, The Haradinaj defense is ordered to upload a public redacted version by Monday, 31 January, redacting the paragraphs that we previously mentioned, and the registry can mark it as redacted with the same exhibit number. Excuse me, you do not have to upload that document. It's done as a public document. Having finished the testimony of the last witness and having admitted these last exhibits, is the defense ready to close their case? Mr. Cadman?
I know that Mr. Rees wants to address you on a point. I will follow. At this stage, no, we are not ready to close the case for reasons that will become apparent.
Mr. Rees?
Your Honour, the defence is not ready to close its case. There is an outstanding disclosure challenge that needs to be addressed. We've had directions to respond on a curtailed timetable by 4 p.m. today to the disclosure challenge. We will be responding by 4 p.m. today as directed. We will then need to await the decision of the trial panel, and if disclosure is ordered, consider what steps, if any, to take in relation to that further disclosure. And if disclosure is refused, to consider whether to seek leave to appeal from the decision. And we cannot at this stage preempt that process. We will wish to wait to see what the outcome of that disclosure challenge is.
Thank you. We'll look forward to seeing your submission this afternoon.
Your Honour.
Yes, Mr. Cadman.
We have already filed, our submission was filed yesterday, so we're waiting Mr. Rees's today and then await your...
Understood. Thank you very much. Anything further from you, Ms. Polici?
From our side, Your Honor, thank you.
Before we move to the subject of detention review timeline, I have a reminder for both defense teams. On 21 December 2021, when issuing the latest detention review decisions, the panel ordered the parties and the registrar to file by 24 January 2022 public redacted versions of their respective submissions, taking into consideration the public redacted version of the detention decision. The SBO and the registry did so, the defense did not. The panel orders the Gucati&Haradinaj defense to file public redacted version of their respective filings F-499 and F-500 by 31 January 2022. The redactions applied by this panel must be followed. The parties are also instructed to submit to the registry by 4 February 2022 any outstanding questions regarding the accuracy of hearing transcripts in accordance with the standard procedure. Last week, the SBO and the Haradinaj defense agreed to request that the next submissions on detention be deferred within 10 days after the Court of Appeals panel rendered its decision. The Gucati defense needed additional time to consider this matter. Before I give you the floor, Mr. Rees, I want to make the following clear. The timeline for review will not be deferred if the Gucati defense does not ask for it. The panel is also mindful that the 2-month deadline in Article 41 of the law is a compulsory one and should not be varied lightly. Even if the panel decides to defer this timeline, it is inclined to setting a cap, a maximum period of waiting. If the Court of Appeals panel does not render a decision within that period, the panel will proceed with its review. Now, Mr. Rees, you may submit your position.
Well, I'm very grateful for the trial panel's indication in Your Honour's last remarks. It chimes with our concern about the process being left open-ended. So through inter partes correspondence, we reached the following agreed proposal, that the review date remains, at this stage at least, the 21st of February 2022, that the SPO file their submissions on detention within 3 days of the Court of Appeal decision, or at the latest by the 14th of February 2022. Defence will respond by the 17th of February 2022. If there has been no Court of Appeal decision received by the 13th of February 2022, any joint request to extend the review date to be submitted by the 14th of February 2022. The reason why we proposed that timetable is it did seem to us that there is still time for the Court of Appeal to return a decision before the next mandatory review date. We've agreed a shortened timetable, working on the basis that to allow for time to see if the Court of Appeal does return that decision. If they don't, then we will discuss on an inter-parties basis at that stage whether to make a request to extend the review, and if so, to submit it by the 14th of February.
Your Honor, the SPO has been notified of the proposal of the Gucati defense and has already conveyed that it would agree to this proposed course of action.
We have also so indicated.
We will enter an order later carrying out that plan if possible. Next, we turn to the Monday status conference. We will hold a status conference on Monday, January 31st, to hear submissions on the agenda you received last week. That is filing F527. If any of the parties wish to make written submissions in advance of this conference, these should be on file by 4 p.m. this afternoon. The panel gave advance notice of this deadline via email earlier this week. If the SPO intends to request leave for rebuttal evidence, the panel expects that an oral application be made on Monday during the hearing. Ms. Bellici, you don't have to answer if you're not ready, but do you already know whether you will be making such a request?
We don't expect to making any request for rebuttal evidence, Your Honor.
Thank you. Depending on the submissions made at the status conference, the panel will issue relevant written or oral orders on Monday or Tuesday, January 31st or February 1st. Any other matters to be raised at this time?
Can I just raise one query, Your Honour?
Yes.
The indication of the orders for written submissions ahead of the status conference, and indeed the agenda for the status conference itself, was provided before the disclosure challenge arose and was predicated on the basis that without any change of circumstance, it was anticipated that defence cases would close today at 4 p.m. That can't happen at this stage, Your Honour. So I raise whether in those circumstances the appropriateness of proceeding to consider the post-evidentiary proceedings agenda. I understand that we have had a provisional discussion way back in, I think, the first week of December. And clearly, at a status conference, we will continue to give assistance to the court in planning provisionally the way ahead. But we won't be in the position where we had envisaged, whereby the cases would be closed today.
Thank you. And of course, you are not required to make a written submission. We have given you the opportunity to make an advance written submission, which it sounds like you're not going to be in a position to do, but we will still give you an opportunity perhaps on Monday for for oral submissions, and you'll have to see what the rulings are in the meantime. And I understand your point. If we have to make another provision on Monday, we will do so.
Your Honour, we are, of course, more than happy to give assistance to the court. And we may submit a written submission ahead of the status conference. But if we do, it will be a provisional one on the basis that the case hasn't closed, Your Honour.
I understand that perfectly, and that's certainly your right, and we encourage you to do that ahead of time if that's what you want to do, and the same goes for you, Mr. Cadman, and to the prosecution. So, anything else? Appreciate your time today, and we will see you Monday at 9:30 in the morning, and perhaps move on. So thank you very much. We are adjourned.
All rise.